Do you think the statute, when with the word habitual added, you make a big deal about that in your brief, really does then reduce to addiction?
So it certainly the addiction prong would be irrelevant at that point because you have to be a habitual user to fall within the definition of addiction. And it would be particularly odd because that's not enough to make you addicted to. You need to be habitually using so as to either endanger the public health and safety, et cetera, or to have lost the power of self-control. So it's really, the addicted to prong is designed to kind of be narrower, yet all of a sudden you'd have this unlawful user prong that's so broad that it renders that prong irrelevant. I don't think that that's really an available interpretation, a kind of a coherent interpretation of this statute when Congress set out two different concepts that it was trying to get at.
Murphy, I wonder, do we need to get into much of this about how the government could proceed or with categorical versus individual or how it applies to addicts? He wasn't charged under that part of 922G3. And all we know, I mean, the only thing we know in the record is he uses some marijuana. We don't know how much or in what potency a few times a week. And why isn't it just enough to say, whatever else may be true, that is not an habitual drunkard?
We would be happy for the court to resolve the case on that narrow ground. I mean, I'm trying to be very responsive. I appreciate the court wants to think about this statute as a whole, but you really don't need to answer any of the questions about the addicted to prong today. And really, even as to the unlawful user prong, all you have to say is either whether the government's thinking about this individually or categorically, they just can't get there simply by saying somebody uses some unknown quantity of marijuana, some unknown time of day, a few times a week. We are very happy to prevail on that narrow ground.